We're on the record in cause number 328506. The case is styled the state of Texas versus Johnny Bryant Sawyer. We have Mr. Sawyer, who is appearing with his attorney, Mr. Bruce Gregory. Mr. Sawyer, how are you doing?
I'm doing good.
Okay, that's good. Now, Mr. Sawyer, you're represented there with your attorney, Mr. Bruce Gregory. Mr. Gregory, how are you doing?
I'm fine, Your Honor. Thank you. How are you?
I'm doing fine, thank you. Now, the state is represented here by its Assistant District Attorney, Mrs. Ashley Ramos. Mrs. Ramos, how are you doing?
I'm doing all right.
That's good. Now, the court uh, earlier today had Mr. Sawyer's case on its docket, and Mr. Gregory brought to the court's attention that he had previously filed a motion in this case, and the motion was is titled Motion to Modify Bond Restrictions. And after I guess some investigation, we've discovered that the court had not set any bond restrictions at that time. And so Mr. Gregory was presented. Mr. Gregory, would you presented a copy of, or do you just have like a little standard copy of our standard bond conditions in County Court Law number 2?
Your Honor, I had the one that you filled out and you actually wrote on it. And
Yeah.
my understanding is that you also signed it as it shows right there.
Oh, yes. Okay.
While you signed it, I do not think that you filed it.
No, we didn't file it because at the time we was going to proceed, but then when we realized that we had to have a hearing, I think we just gave you a copy and the court kept a copy. So it never was filed. It never was filed because we wanted to have a hearing before the court entered entered the bond conditions that the court will approve of. We want to give each side an opportunity to respond to the motions that you file. Now, Ms. Ramos, did you have an opportunity? Well, first of all, did you receive the defendant's motion to modify bond restrictions?
Yes, Your Honor. And in doing my research on this, I did find where Mr. Gregory had also served Shaylin with a copy of that. I just had not gotten a copy of it myself. And so our office did receive it initially when it was filed as well.
Okay.
And I've reviewed it.
Okay. Now, Mr. Gregory, you have reviewed the standard bond conditions in County Court at Law number 2. Is that correct?
That is correct, Your Honor.
And I think just from reading your motion, your modification involves your requested modification involves condition number 3 on standard bond conditions in County Court at Law number 2. Is that correct?
Yes, Your Honor.
Okay. And just for the record, what I'll do is condition number 3 basically on our standard bond condition states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And the alleged victim in this case is a gentleman by the name of Mark Newman. Is that correct?
Yes, sir.
Okay. Now, Mr. Gregory, it's your motion. Would you like to proceed?
I think the motion pretty much speaks for itself. The modification we're asking is that under this number 3, that the defendant be allowed the exclusive use of the residence at 4849 Grant in Groves, Texas, which is also where the alleged victim resides. And for the reasons set forth in the motion, I'm asking for the defendant to be allowed to remain in that house as he has for the previous 40 years.
Now, Mr. Gregory, you mentioned something about exclusive use of the
Yes,
house?
yes. As I set forth in the motion, the reason he's there is he's the surviving spouse. It was his spouse's home, and prior to their marriage, some 40 odd years ago, she's passed away. He's the surviving spouse, and he has a constitutional life estate, which gives him the exclusive right to live in the house, even though the house was left to the children, or two of the children of the decedent.
Now, that issue should be probated, I mean, should be prosecuted I guess, in a probate setting.
Well, the estate has already been probated, and I was the attorney who probated the estate, but the spouse, the surviving spouse, just has a right to live there. And all we're asking for the court to do is to allow him to continue to live there. Back in the fall, before this alleged assault occurred, the defendant allowed his stepson to reside at that same house. And he only has been there since like September of last year. And the incident occurred after that. But I don't think it's fair to a 77-year-old man to be forced out of his house because he's a defendant in a criminal matter.
Okay, Mrs. Ramos, you have a response?
Yes, Your Honor. The responses, I guess when I read this, I wasn't getting that we were making this to be the exclusive house of the defendant. I am in agreement that we could allow the defendant to still live where he is currently living, and that he shouldn't be forced to have to move out of the place that has been his home. And I don't mind modifying the bond conditions to allow for him to still live there. But I'm not sure about the court's jurisdiction over being able to allow exclusivity to a home.
Right.
I guess my reason for putting that in there is that if the defendant is there and the alleged victim is there, then they're obviously going to have contact with one another. I just didn't want my client to have to move out and try to find a place to live when he doesn't have the resources to do that. But I don't mind if he's just allowed to live there. I just didn't want him to have to move out, and I didn't know how he could not have contact with the alleged victim if they were living in the same house. It seemed like an impossibility.
Right. I'm thinking also, I mean, I think, well, these issues that that's actually stated in the motion is, uh, as you said, you probated the estate. Uh, uh, these are issues for the probate court. In this case, the court, uh, pursuant to, um, I think it's 17 or section or article 17.40 of the Texas Code of Criminal Procedure. Hold on a minute. Basically under that it says conditions related to victim or community safety to secure the defendant's attendance at trial. A magistrate may impose any reasonable condition of bond related to the safety of a victim of the alleged offense or to the safety of the community. And so one of the standard um, conditions is, as stated in the standard bond conditions number 3, the defendant shall not communicate either directly, indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Now, in this case, Mr. Mark Newman. Now, the state says that they are not opposed to the portion of condition number 3, removing the condition that says not go near any residence. Is that correct, Ms. Ramos?
Yes, Your Honor.
Okay.
Well,
Okay, go down.
in my motion, I did put in there to the exclusion, if we just said that the defendant's permitted to reside at 4849 Grant Groves, Texas, and stop right there, would the court approve that?
Well, I'm not going to say where he can or cannot reside. I don't think the court has authority to do that in these standard bond conditions. As I said earlier, I think the issue is, well, not the issue, but from what you were saying, Mr. Gregory, the defendant, Mr. Sawyer, has lived in the home. Obviously, he lived there until his wife died. Well, he was living there and his wife died. His wife actually is the mother of the complaining witness, or the victim in this case, who is the stepson of Mr. Sawyer. And I was just looking at your motion. Apparently, y'all, when you went to court, Mr. Sawyer, I think you said he had a life estate. Is that correct?
Mr. Sawyer has a life estate in the property. He can live there as long as he chooses.
I think is right. The life is now apparently, and I'm not going to get into issues of whether, community property or anything. I'm just reading your motion saying that the alleged victim was given a half interest in the home in his mother's will. The remainder of the estate was given to Mr. Sawyer, who is the defendant. So apparently both parties have an interest in there, but you said that Mr. Sawyer obviously has a life estate. So in reference to the court's ruling on the bond, our wording is basically going to stay standard. We're not going to devise an order saying who will be given exclusive use or possession of this property in any way to affect the order that is in place in the probate case. What we will do is, our concern here is the safety of the victim. But in light of the fact that both the victim and the defendant lives in the same home, I think you said Mr. Sawyer has lived there for about at least 40 years or more. And Mr. Mark Newman, the victim, I guess recently moved into the home following the death of his mother, and maybe following the probate of the will. I don't know. But with that in mind, I need to, I'm just looking at condition number 3, shall not communicate directly, indirect with the alleged victim. Now, Mrs. Ramos and Mr. Gregory,
Yes, sir.
I'm gonna look at it at this standpoint. I'm just going to start with the communication aspect.
Yes, Your Honor.
And I'm thinking about maybe modifying it a little bit, saying that the defendant shall not communicate either directly or indirectly with the alleged victim in a threatening or harassing manner.
Yes, Your Honor. I was going to suggest possibly amending the language to that. I know that's what we will sometimes put in a probation type order, so I'm not opposed to amending it to have it with that language.
So you could communicate, it just can't not be in a threatening or harassing manner. Do you, Mr. Gregory, do you have any problem with that?
I
Or
think,
any
it's a good
suggestion?
solution, Your Honor.
What, I couldn't hear you. What you said?
Solution.
I think you broke up. We couldn't hear you.
I concur with the prosecutor. That would be good wording.
Okay. Let me make that note. Let me see.
Yeah, mainly I did not want him to be excluded from that residence because of the wording of the bond restriction.
Right.
Does that include him being in a threatening manner, or does that just apply to me?
That applies
Because
to
that's
you.
what started
No,
the thing. He was the
no,
one doing
I
the
know, but
threatening.
he's not the one who's a defendant. It only is one way.
Let me see. Now the second part of this condition, it says, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Mrs. Ramos, you have any suggestions or any recommendations?
My recommendations was that in this case to possibly remove that condition.
Okay, remove that whole second part of that sentence.
Yes, Your Honor.
And then we're gonna say you're gonna remove it everywhere. Well, starting at and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Is that correct?
Yes, Your Honor.
Okay, Mr. Gregory.
That's acceptable to us, Your Honor. We would appreciate that.
Okay. Now, Mr. Gregory and Mrs. Ramos. Now, I've scratched through this, and this is what I'm going to do. I'm going to read to you what's going to be in the standard bond condition. But I need to let you know that I'm gonna have the court reporter probably retype it because I don't want to just have the stuff with my handwriting all over it. And so let me do this here. Starting at the top, standard bond conditions. Well, we're gonna say modified standard bond conditions. Okay. Okay, it's gonna say modified standard bond conditions in county court at law number 2. And it reads, following the arrest and or accusation in county court at law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Mr. Sawyer, do you understand that condition?
In this condition.
Yeah.
Commit no offense against Texas laws or any other laws. Do you understand?
Yeah.
Speak loud enough for the judge to hear.
Yes.
Okay. Now, number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44A2 and C2. Mr. Sawyer, do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim, and I'll put his name there, but with the alleged victim of the pending offense, Mark Newman, in a threatening or harassing manner. Do you understand that?
Okay. What does indirectly mean?
No. I'll let the court respond.
Well, I mean, if you're directly communicating it to him in a threatening harassment, or if you're using somebody else to communicate to him indirectly, that can be considered an indirect communication. If you're threatening, that's just one way. But if it's not direct, anything else will be indirect. If it's directed toward Mr. Newman in a threatening or harassing way.
It might be that you say, well, you go tell him this. That's an indirect communication with him.
Oh, okay.
Okay. Now, Mr. Sawyer, do you understand that?
Yes.
Now, actually, condition number 4 does not apply here because this only applies in cases where there is a DWI second or another or DWI or higher than the DWI second. And you do not, in this case, it's not a DWI case. That's why I say this only applies in DWI cases, and you do not have a DWI case.
Okay.
Do you understand that?
Yes, sir.
Okay. So what I'm going to do, we're going to have our court. Now, let me ask Ms. Ramos, do you have any objections?
No, Your Honor.
And Mr. Gregory?
No objections, Your Honor.
No objections? Okay. So what I'm going to do, we'll have our our court reporter draft the modified standard bond conditions. I'll sign it and we'll e-file it. And I think if we e-file it, y'all, both the state and the defense get a copy?
Yeah, we will get our copy through the e-file system.
Okay.
We should. I need to have this case adjusted. It still has Miss Musgrove on it.
Okay. Okay. Now, is there anything else that we need to go over with regards to this bond condition?
Nothing from the defendant, Your Honor.
Oh, let me do this here. Now, Mr. Sawyer, you understand that if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, that means you can be arrested and put in jail, if your bond is revoked. Do you understand that?
Yes, sir.
All right. So let me add another thing. So thus far, I think this offense allegedly occurred on November 14 of 2020. And I would imagine that all parties are still living in the same household. Is that correct?
Yes, sir.
Okay. All right. So let's make sure that we maintain and keep the peace.
Yes, sir.
All right. Ms. Ramos, you have anything else?
No, Your Honor.
Mr. Gregory, do you have anything else?
Nothing further from the defendant, Your Honor. Thank you.
Okay, Mr. Sawyer, you have a blessed day, and you're excused. And Mr. Gregory, you have a blessed day as well, and you're excused.
Thank you, Your Honor.
Thank you. You too, sir.
All right, you're welcome. And Mrs. Ramos, you're excused as well, and you have a blessed day.
Thank you, Your Honor.
All right.